Welcome back. Last time we talked about the Congress and the constitutional powers the Congress enjoys and some of the limits in cooperation it must do with the executive branch. Today, we're going to talk in terms of the executive branch and the Supreme Court and how all three of the branches of our government cooperate and work against each other. So let us start. Article 2, Section 1. The executive power shall be vested in the President of the United States of America. He shall hold his office during the term of 4 years, and together with the Vice President chosen for the same term be elected as follows. Now, this has changed a little bit, but the important thing for our purposes is to remember that the President is elected for 4 years. Each state shall appoint in such manner as the legislature thereof may direct a number of electors, equal to the whole number of senators and representatives to which the state may be entitled in the Congress, but no senator or representative or person holding the office of trust or profit under the United States shall be appointed as an elector. Again, this is the famous Electoral College. So each state gets the total number of electors that they have as senators and representatives, but a senator or representative cannot be an elector. Usually what happens is electors are people who are maybe retired judges or professors or union representatives or people who are just interested in government. They become an elector. There is no law that says the electors must vote for the candidate that gets the majority of the popular vote. What normally happens, and what's happened in the past, is the winner-take-all aspect of that. So let's talk about it for a second. So again, if we use 2000 as an example, or 2016 as an example, you have the candidate who won the popular vote did not win the presidency. How did that happen? So imagine that we have, again, Vice President Gore and Governor Bush, and they've run a campaign. It's the next day and we're counting the votes. And so, and again, these are just hypothetically made up numbers, but let's say that Vice President Gore won New York State by 1 million votes, and then he won California by 23 million votes. And this makes, right, 24 million. So we have Gore, and then we have Bush, and the former governor of Texas, and as we know, President Bush wins Texas by 3 votes, and wins Florida by 4 votes, and wins South Dakota by 2 votes. And so what we see is, as it's winner take all, if I win South Dakota or Montana or Wisconsin by 1 vote, that gives me all of their electoral college electors. So even though Vice President Gore would have a lead of 24 million, and again, if we would add all these states together, right? Let's just say, and Bush wins each state by 2 or 3 votes. So the most, let's just say, again, he has, let's just say 36 vote over Gore's total in those states, assuming there are 14 or 15 states, two per state, but Gore keeps on winning the states he wins by millions of votes. this is how this imbalance happens. So some states are reforming or changing, and they're saying that for every congressional district, it's winner take all. This is happening in some of the states, but not in all. And there's still, again, becoming a controversy on the Electoral College and the issues that surround electing a president. The electors shall meet in their respective states and vote by ballot for two persons, of whom one at least shall not be the inhabitant of the same state with themselves. Again, this has changed. We no longer vote for president and vice president this way. It was in a separate ballot. We now vote for the ticket. The electors of the Electoral College vote for a ticket. And then shall make a list of all persons voted for and of the numbers of the votes for each, which list they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the President of the Senate, the sitting Vice President. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes shall be appointed, shall be the President, if such a number of the majority of the whole number of electors appointed, and if there be more than one who have such majority and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for president, and if no person have a majority from the five highest on the list, the said House shall in like manner choose the president. But in choosing the president, the votes shall be taken by states, and the representation from each state having one vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. In every case, after the choice of the president, the person having the largest or the greatest number of votes of the electors shall be the vice president. But if there should remain two or more who have equal votes, the Senate shall choose from them by ballot the vice president. So again, let's talk about this in a more vernacular way. You have, again, let's say there is a tie. There is no majority of the Electoral College. Then what will happen is the election or the decision to determine who's president goes to the House of Representatives. In the House of Representatives, each state has one vote. Having one vote for California, you basically have to get 52 people to decide on who should be president. While in Wyoming, it would only take one person. The main reason we have the Electoral College is to protect small states in this process of electing a president. And it gets turned almost on its ear, right? It gets turned almost upside down when one thinks of the dynamics of one vote, one state in the House of Representatives and how much power a potential single representative state like Wyoming or other small states would have if this situation did take place. This situation did take place again one time in our history when when John Quincy Adams was elected president. So we have one vote per state. Now again, if the House of Representatives cannot make a decision, cannot determine a majority in this vote, then it moves on and the Senate would then pick a vice president. So at least we would have a vice president who would probably be acting president until that question would be settled. So basically, we elect the president through the Electoral College. Why do we do this? Because it's in the Constitution. Why is it in the Constitution? Well, basically to help defend the rights of small states. The Congress may determine the time of choosing the electors and the day on which they shall give their votes, and which day shall be the same throughout the United States. No person except a natural born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of President. Neither shall any person be eligible to that office who shall not have attained the age of 35 years and been 14 years a resident within the United States. So again, this is the only mention in the Constitution where a person is born is considered part of a qualification. The president cannot be foreign born. So members of Congress can be foreign born, senators can be foreign born, people who serve in the cabinet can be foreign born, but they cannot be president. So Secretary of State Henry Kissinger was foreign born, so he could not qualify to be president. So when he was Secretary of State, he would not be eligible in that line of succession that we talked about last time. Madeleine Albright also was a Secretary of State who was foreign born. So this is the only part of the Constitution, and really only the part of the law that I'm aware of, that directs the birth of a person as a disqualification for office. And as an aside, Arnold Schwarzenegger, when he was governor of California, tried to get this amendment and tried to change this law as part of the Constitution. In the case of the removal of the president from office, or of his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve on the vice president, and the Congress may by law provide for the case of removal, death, resignation, or inability, both of the president and vice president, declaring what officer shall then act as president, and such officer shall act accordingly until the disability be removed, or a president shall be elected. The president shall, at stated times, receive for his services a compensation which shall neither be increased nor diminished during the period for which he shall have been elected. And he shall nor receive within that period or other emolument from the United States or any of them. So the president is paid, and up until the year 2000, the president was paid $200,000 a year, and now the president gets paid $400,000 a year. You might, again, think that's a lot of money, but as a relational or as a measuring point, U.S. Grant, when he was president in the 1870s, made $100,000 a year. Before he enter unto the execution of his office, he shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office of the President of the United States and will to the best of my ability preserve, protect, and defend the Constitution of the United States. There's no so help me God in the official oath. But why is this oath important? This oath is important because the obligation of the President of the United States, the oath that the President gives freely, the obligation he gives freely, is the protection of the Constitution of the United States. When you read biographies of Lincoln, Eisenhower, other presidents, this is the point in which they really believe that they become president. This is the defending of the Constitution is one of the things that really motivates many presidents who have held the office. So that's how we elect the president. What are the powers of the president? Section 2. The president shall be commander-in-chief of the Army and the Navy of the United States and of the militia of the several states when called into the actual service of the United States. He may require the opinion in writing of the principal officers in each of the executive departments upon any subject relating to the duties of their respective offices, and he shall have power to grant reprieves and pardons for offenses against the United States, except in the cases of impeachment. The president cannot pardon people who are involved in the impeachment of the president. He shall have the power by and with the advice and the consent of the Senate to make treaties, provided that 2/3 of the senators present concur, And he shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers, consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the course of law, or in the heads of department. So the President has the appointment power of the executive branch. The President also has the role of Commander-in-Chief. As Commander-in-Chief, one can think of Commander-in-Chief, a definition of Commander-in-Chief, as an ultimate or the ultimate authority on military matters. So again, think of how our constitutional structure is constructed. You have Congress that has the power of determining war and peace, declaration of war, but it is the President who must command. It is the President who is Commander-in-Chief. The President shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of the next session. So these are called recess appointments. Recess appointments. So for example, President Trump threatened to use recess appointments in which the Senate is out of town and the Senate is in recess, and the appointees serve until the end of the Senate term. Section 3. He shall, meaning the President, from time to time give to the Congress information of the state of the Union, and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses of either of them in the case of disagreements between them with respect to the time of adjournment. He may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all officers of the United States. So if you do have a relative or a friend who's been a commissioned military officer as a second lieutenant, ultimately he will be getting a certificate that is signed by the President. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors. This is the definition of impeachment. If you remember last time, we talked about what impeachment is. Impeachment is an indictment, and then the Senate has its court. So this is the definition. So every time a president has been impeached, the question is, was the conduct of, was the president involved in treason, bribery, or high crimes and misdemeanors? Oh my goodness, if I could spell, that'd be dangerous. This is the criteria. Now again, we've talked about impeachment, we've talked about how many presidents have been impeached, and this is, again, why people don't get convicted. So that's the presidency. We spent over an hour and 15 minutes talking about the powers and the express powers of the Congress, and now we spend maybe 5 to 10 minutes on how the Constitution addresses the executive branch or the president. Now again, compare that to the media and to our perception of who has power in the world. The nickname for the president is the world's most powerful man or person. and he may be, and in the future she may be. But in the constitutional structure, it's very, very small. It's a very, very executive office. This was the primary rationale for the adoption of this Constitution, because the Articles of Confederation had no executive. And in areas of foreign policy, in areas of trade, in areas that an executive is needed, that's why they have it. Another highlight is the State of the Union address, right? The State of the Union is mentioned in Section 3, and it's really one of the only formal constitutional requirements the president has. So now we move to Article 3, the Supreme Court. Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme Court and inferior courts, shall hold their offices during good behavior, and shall at stated times receive for their services a compensation which shall be not diminished during their continuance in office. So again, we've gone through the elements of the executive branch. Now, what about the elements of the judicial branch? So the judicial branch, or Article 3, highlights a couple things. First of all, judges have lifetime terms. They serve for their lifetime. The only condition to that is good behavior. Again, judges can be impeached just like presidents. It's the same process. So if a judge is caught, again, accepting a bribe or being corrupt or guilty of treason or high crimes and misdemeanors, that judge can be removed. Other than that, the judge serves for their lifetime. The Supreme Court has, as Congress has all the judicial power, right? The Supreme Court has all the judicial power. The Supreme Court is the supreme interpreter of the law in this country. Section 2. Judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States and the treaties made or which shall be made under their authority, to all cases affecting ambassadors, other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to the controversies to which the United States shall be a party, to the controversies between two or more states, between a state and a citizen of another state, between the citizens of different states, between citizens of the same state claiming lands under the grants of different states, and between a state or a citizen thereof and foreign states, citizens, or subjects. Basically everything, right? The Supreme Court has authority and jurisdiction over all types of legal cases. In all cases affecting ambassadors and other public ministers and consuls, and those in which the state shall be a party, the Supreme Court shall have original jurisdiction. And again, in the next section of the course, we'll talk about this difference between appellate and original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction both as to law and fact, with such exceptions and under such regulations as the Congress shall make. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state in which said crimes have been committed. But when not committed within any state, the trial shall be at such places or places as the Congress by law have directed. Section 3. Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. Again, we have a definition of treason because treason is one of those offenses that can be used to impeach a president or get rid of judges. No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act or on confession in open court. This is very strict, a very, very difficult standard to have someone convicted of treason, isn't it? But why? Why was that? Well, primarily, one has to remember that the founding fathers were considered traitors when they rebelled in the Revolutionary War. So they wanted to have two witnesses. Well, if you're going to do something that's pretty bad, it's going to be pretty tough to find two witnesses, right? It's a pretty difficult standard, as I said. Article 4, Section 1. So we've talked about the three branches of government, and now the Constitution sums up and summarizes this new national government and how it affects the individual. Article 4, full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. Section 2, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. A person charged in any state with treason, felony, or other crime, who shall flee from justice and be found in another state, shall, on demand of the executive authority of the state from which he fled, be delivered up to that removed from the state having jurisdiction of the crime. No person held to service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged in such service or labor, but shall be delivered up on the claim of the party to whom such service or labor may be due. Again, the remnants of slavery, right? If a slave ran away from a slave state to a free state, the person who owned that slave could call that person back. Section 3, new states may be admitted by the Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state, or any state may be formed by the junction of two or more states, or parts of states without the consent of the legislatures of the states concerned as well as the Congress. Puerto Rico is already, from the American point of view, to be the 51st state. Congress has passed resolutions that make Puerto Rico the 51st state. The state legislature has passed some resolutions, laws about that. Now, the people recently voted to become, at least consider that possibility. The Congress shall have the power to dispose and to make all needful rules and regulations respecting the territory or other property belonging to the United States. And nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. Section 4, the United States shall guarantee to every state in this union a republican form of government, republican with, again, a representative democracy, not the political party, and shall protect each of them against invasion and on application of the legislature or the executive when the legislature cannot be convened against domestic violence. If there is a domestic terrorist attack, a riot, some type of anarchy that happens in a state, the governor and the mayor, whoever, can have request federal help. Article 5. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislature of the 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all the intents and purposes as parts of this Constitution, when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as of one of the mode of ratification may be proposed by the Congress, provided that no amendment may be made prior to the year 1808, shall in any manner affect the first and fourth clauses of the 9th section of the first article, and that no state without its consent shall be deprived of its equal suffrage in the Senate. So the amendment process of the Constitution. The amendment process of the Constitution goes through Congress, 2/3, and the state legislatures, 3/4. Now, once you have an amendment that is just as powerful or has the same part of the Constitution as the original documentation of the first three articles that we've read. So just because something's an amendment doesn't mean it has any less or any more effect or power. So we can amend the Constitution two ways, traditionally by this way, or you can have a convention. Right? You can do it legislatively or you can do it by convention. We've never had a convention. And again, probably a good idea not to have a convention because you don't know what types of things are going to be thrown in. You don't know the dynamic of a convention. And so remember, the Articles of Confederation was totally changed because they just wanted to reform it. And the first thing the convention did in Philadelphia was to say, let's throw it out. Article 6, all debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. The founding fathers are saying, we are responsible to any debts or obligations coming from the Revolutionary War, coming from the Articles of Confederation. It's one spectrum. It's one connected tissue. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made of which shall be made under the authority of the United States shall be the supreme law of the land. This document, this Constitution, is the supreme law of the land. The states do not. The states cannot ignore the Constitution. So, the Constitution is the supreme law. It is the touchstone. When we have a controversy, when we're looking to the law, what do we look at? We look at the Constitution. And the judges in every state shall be bound thereby, anything in the Constitution or laws of any state on the contrary notwithstanding. So when you have a city that proclaims itself a sanctuary city, that's in direct violation of the Constitution. That's in direct violation of this idea of the supreme law of the land. Judges are supposed to be following federal law over local law and the constitutional law over statute law. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. Again, people may say, the president is not my president. You don't have that choice. The congressman is not my congressman. You don't have that choice. If you are a person who is an elected official, if you are a person who holds a public trust, you must follow the Constitution. You must. But no religious test shall ever be required as a qualification to any office or public trust under the United States. This phrase, no religious test, has been deeply misunderstood. What it means, again, if you remember last time when we talked about the Enlightenment, it means that no fear nor favor. So if I'm a person of faith, or if I'm not a person of faith, it should not matter if you are appointed. It should not matter if you're running for election. It should not matter if you're in a public institution. There is no religious test. So again, this is an example of the Founding Fathers and how they looked at religion as a personal institution, and how no one should be punished nor favored because of their faith. The next article, Article 7, and the last article that we're going to talk about in this section, talks about the ratification. Okay, so again, going back to popular sovereignty, how do we get the public, how do we get the people to view this document as legitimate? The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution, between the states so ratifying the same, done in the convention of the unanimous consent of the states, present the 17th day of September, the year of our Lord, 1787, and of the independence of the United States of America, the 12th. In witness thereof, we are here to subscribe our names. And of course, George Washington was the chairman or president of the convention. That is the government of the United States. 3 branches: the legislative, executive, and judicial, and the supreme law of the land, the social contract, the nuts and bolts of our government. But it wasn't a tabula rasa. The government was already in existence, right? State governments, and local governments were in existence. We get rid of the Articles of Confederation because the Articles of Confederation had no executive, were considered weak. And the federal government was a superstructure that was basically welded on to these governments. Okay? Welded onto the governments. So you had the federal government or the national government, you had the state governments, and you had the local governments. Well, again, keep in mind this generation fought the Revolutionary War, and people like Patrick Henry said, wait a minute, why did we fight a war against tyranny when you just created another layer of government? You call this person a president, but this person he's a king. He's just like a king. Why do we have this? Why did we do this? And this is where the ratification debate comes through. More importantly, this is only half of the Constitution. This Constitution has another whole section to it that you may be familiar with, called the Bill of Rights. And of the amendment process, sort of the deal that was made to ratify the Constitution was the first 10 amendments would be passed in order to protect the individual. This was called the Bill of Rights. The first time in history, you have legal code, amendments of the Constitution that protect the individual, not from other individuals, but from the state. This is the important aspect of the Bill of Rights. Next time, we will talk specifically about the amendments. And we'll read, again, every amendment bit by bit by bit. The objectives for today were to understand the elements and the characteristics of the executive branch, of the judicial branch, that the Constitution is the supreme law of the land, and that no religious test is required to serve your government. Thank you.